Thank you for joining us for your covered Social Security after DOMA. Up on your screen right now is just a little bit of background information to keep in mind that obviously Social Security is a complex federal program. We can't get into all of the intricacies in this 1-hour webinar. We'll do the best that we can, but there are other options you have for getting additional guidance, both from GLAD and you may also want to seek other kinds of resources. So again, here we are. You're covered, Social Security after DOMA. Thank you again. We had really great response for this webinar. Obviously shows that there are a bunch of questions out there. And I just wanted to say a few things. My name's Amanda Johnston. I'm with GLAD, and I just want to do the welcome before we get started and give you a few housekeeping bits of information. So Gay and Lesbian Advocates and Defenders, for those who don't know, we are a legal advocacy organization. We work in New England and also nationally on to effect positive change in the law for LGBT and HIV positive people. We were on the forefront of the legal challenge to the Defense of Marriage Act and are very happy to now be in the position to be sharing information about your rights and responsibilities now that DOMA is gone. I want to thank our many organizational partners who helped us get the word out about this. And you can see them all there on the screen. They did a great job, and we really appreciate everybody's help and support. So just a few housekeeping things. I know that you have questions. We've already gotten a couple. The way we're doing questions on this webinar is you can type in your question. You should see a question or a chat box on the lower right of your screen or somewhere on the right hand of your screen. So if you just type in your question, we'll see it here. And Vickie, who's going to be presenting today, will answer questions at the end of the presentation. She's leaving plenty of time to do that. So feel free to send in your questions at any time, and we will cover them at the end. And a recording of this webinar is being made, and we'll post it tomorrow at glad.org/DOMA. We'll also be sending out an email to everybody who registered with a link to the recording as well as some additional related materials. And I do just want to say that you can check glad.org/DOMA for additional information about your rights and other information sort of post-DOMA on Social Security as well as other federal programs. And you can also always contact us at GLAD Answers at gladanswers.org. The information's on your screen right now. You can also call us at 800-455-GLAD if you have specific questions, things that don't get answered today, or you need additional information about this or any other LGBT or HIV related legal issue. So, having said all that, I want to introduce you to Vickie Henry, Senior Staff Attorney at GLAD, who is going to tell you all, hopefully, you need to know about Social Security in a post-DOMA world.
So I just wanted to say welcome to everyone. Thank you for joining us, and we're going to give you a whole lot of information today. I just want to start with an overview of the information we're going to cover. Just so we're all on the same page, I'm going to start with a brief overview of Social Security's marriage-related benefits. Then we'll turn to what the Social Security Administration is doing to implement its post-DOMA guidance and life after the Supreme Court's decision in Windsor. At that point, I'm going to come back to the specific Social Security retirement benefits that we're going to drill down on, and that's the Spousal Retirement Benefit and the Survivor Benefit. Those are the ones that are most common for people, and I'm going to talk as well about how you can maximize your benefits. Now, I know a number of people who've registered are already receiving benefits on their own record, or they have a spouse who is, and we're going to cover some strategies that you could try to see if you could go back to Social Security to try to increase the benefits that you're receiving. And finally, we're going to talk briefly about people who are in civil unions and registered domestic partnerships, because even though they're not married, there is still potentially a mechanism to be able to get Social Security benefits based on their partner's earnings record. So let's just start with the general benefits that are available. The Spousal Retirement Benefit, that's where both spouses are alive, and we're going to cover that in detail. the survivor benefit, which is also known as a widow or widower's benefit, lump sum death benefit, the spousal disability benefit, and children's benefits. So those are the main things that people should be thinking about. And now we'll give a little bit of information about the spousal retirement benefit. This is a benefit that's claimed when both spouses are living, and if you're making this claim, you are claiming based on your spouse's earnings record, either in addition to your own or instead of your own. And what it does is it can raise a lower earning spouse's benefit to up to 50% of the wage earner's benefit. And you should note that it can be claimed by divorced spouses as long as that marriage lasted for at least 10 years. The trick here, though, is you do have to have your spouse has to have applied for benefits with Social Security. They don't have to receive them. They have to be age eligible, and they can then actually suspend their application to allow you to be on their earnings record. Let's put some numbers to this so that this makes sense. So we have a couple, Lee and Pat, that are married in New Hampshire after it became legal to do so. Pat was the higher wage earner, actually, and this, to make this very simple, Pat was the only wage earner. And Pat has earned a Social Security retirement benefit of $2,000. Lee has reached full retirement age, but she did not work enough quarters to apply for Social Security on her own earnings record. So this is where the spousal benefit can be one way that it can be very helpful. And that's because Lee can get a benefit up to half of Pat's benefit, or here $1,000. And this is just a little chart here to explain to you that how DOMA was so devastating. Because while DOMA was in effect, Social Security could not recognize their marriage, and Lee could not get any spousal benefit. So their total family income was $2,000. Once we get rid of DOMA, Lee is able to apply for the spousal benefit on Pat's record, and in fact then they're able to have a family benefit of $3,000, which is obviously significantly higher, and that will go on as long as they are both living. I'm going to take the same couple here and do a variation. So now Lee has worked enough to get her own Social Security retirement benefit, but she was the lower earning spouse, and her benefit is $750. She can do still do the spousal benefit, and what Social Security does is, unless you tell them otherwise, you get your own benefit, and then they use the spousal benefit to bring her up to half of Pat's benefit. We're going to drill down a little bit more later when I get into detail about ways you can use your spousal retirement benefit to delay retiring on your own earnings record. The survivor benefit comes into play, as it sounds like, when one of the spouses has passed away. And what it does is it permits the surviving spouse to receive the greater of his or her own Social Security retirement benefit or the deceased worker's benefit. And again, this can be claimed by somebody who's been divorced as long as the marriage lasted at least 10 years. Putting names and an example here with numbers, we have Jack and Bob, who were married in Connecticut after Connecticut permitted marriage equality, and they're both of full retirement age. Jack receives a benefit of $2,000 on his own record. Bob was the lower wage earner, and he receives a retirement benefit of $750 on his own record. And like the couple in the previous example, he's using the spousal benefit to bring his benefit up to half of Jack's, or $1,000. So if Jack dies first, Bob can switch over to a survivor benefit in the amount that Jack had been receiving, which would take his benefit to $2,000. Now, if Bob dies first, then Jack would just continue to receive his own benefit of $2,000, and he would not receive any additional benefit. Now, I've used a couple of terms that I think it's important to give some definitions just so you're on the same page with me and with Social Security. Claimant is one of the words you will hear. That's the person who's actually making the application for Social Security benefits. So each spouse could be a claimant. Number holder, or sometimes you'll see on the Social Security website an abbreviation NH, which is not New Hampshire in that context, or wage earner is the worker on whose earnings record you are applying for Social Security. So if you're applying on your own earnings record, you are the number holder or the wage earner. And if you are applying on your spouse's earnings record, then your spouse in that case is the number holder or wage earner. Now, there is a term for that experience where both of you are entitled to Social Security benefits on your own record, and that means you're dually qualified, meaning you're qualified for two different reasons, because of your own record and because of a spouse's record. So now I want to talk about Social Security's efforts to implement Windsor and to live in a world without the oppression of DOMA. So let me just step back for a minute. We often get questions from transgender people asking how all of this applies to them, and I just want to mention, if you entered into a marriage as with someone of a different sex and then transitioned, Social Security just treats you as if you have a different sex marriage your whole life. And nobody really complains about that because it's economically advantageous and because people don't usually say, no, you should discriminate against me. So if you enter a marriage as a different sex couple, you can just stay that way even if one of you transitions. If you're transgender and you enter a marriage with someone of the same sex, then you'll just be facing the same discrimination as LGB people, and now you'll be subject to the Windsor post-DOMA implementation. So the general rule with Social Security now is that all marriage-based, or I'm going to say relationship-based claims because we're going to cover civil unions and RDPs, that were pending at the time of or filed after the Supreme Court's decision in Windsor, which was issued June 26, are subject to post-DOMA processing. In other words, Social Security will be permitted, subject to the Social Security law, they will be permitted to recognize these marriages, but you don't have DOMA just striking them out. And so what they've told us, and this is definitely an evolving process, is they are processing some claims. And this is a good place for another note, which is to say, well, why are different federal agencies moving at their own pace and doing different things? And that's because they all have their own law that caused them to exist. And so the Social Security Administration is interpreting the Social Security law, the Internal Revenue Service is interpreting the tax code, and Veterans Affairs is interpreting the Veteran Statute, and so on and so forth. So what Social Security has said is, for married same-sex couples, they are now processing, they're taking claims from everybody, but they are processing and starting to give out benefits when the wage earner was married in a place that permit equal marriage, which, in other words, they permit same-sex couples to marry, or they recognize marriages from out of state, and the wage earner is domiciled at the time of the application or while the claim is pending final determination in a state that recognizes the marriage relationship that they have. And of course, you have to meet all other factors for entitlement. So we've got a map up here that just explains the status of marriage equality, so you can see what your options are, and you, I think, have access to these slides. So the orange or golden states are states where same-sex couples can marry. Oregon, well, let me back up. Illinois is effective June 1st, 2014, and then Oregon is you can't marry there, but they are recognizing marriages from out of state. And then Utah, of course, had a very brief window where people could get married, and right now the federal government has said they will recognize those relationships. And Washington, D.C. is recognizing marriage equality, and that turns out to be super important because if you live outside the country, then the laws of Washington, D.C. determine whether or not the government will recognize your relationship. So it's very important that we have marriage equality there. Now, a couple of notes on this. The claims are limited to ceremonial marriage. In other words, right now they are not addressing anyone who wants to claim they have a common law marriage. And I would say if you want to claim Social Security benefits, you should, you're acting at your peril. If you want to rely on a common law relationship, you should think about ceremonial marriage. Also, the marriage had to be during a period of time when the place of celebration recognized marriage equality. So you want to make sure you married at a time when it was unquestionably legal to do so. And if you did enter into marriage in a foreign country, and Canada is still a foreign country, then Social Security will secure a legal opinion about the validity of the marriage before they will start to pay benefits. Now, Edie Windsor, in the Windsor case, did marry in Canada, so I think you're in pretty good shape there, but I do want to alert people to that possible extra delay in processing their application. Social Security is holding claims They're holding several different categories of claims, and I'm not going to tell you they all make sense because a couple of them don't, but that's what they're doing right now. And I appreciate that they're actually just telling people what they're doing because that's helpful. They are holding marriage-related claims where the number holder spouse lives in a state that does not permit or recognize marriage for same-sex couples. They, for whatever reason, are holding benefits claims by a claimant that has moved to New Jersey. Even though New Jersey now has marriage equality right now, that is what they are doing. And they're also holding claims for a survivor of a marriage that involved a same-sex spouse when the survivor then subsequently marries another person of the same sex. They are, for the moment, holding those claims. They are also holding benefit claims involving a couple that resides in a state where they converted civil unions to marriages and the couple started with the civil union. I think the reason for that is because some states automatically converted civil unions to marriages, other states did not, or for example, Washington converted some, but not if you were over a certain age. So they're still sorting that out, and they have to look at all the states that had a history with civil unions or registered domestic partnerships. They are also holding claims when a member of the couple alleges a prior civil union to someone who other than their current spouse. So if you had a prior civil union with someone, you are going to want to have documentation that that civil union has ended. If for some reason you had one of those relationships and it did not end and you entered into a marriage with someone else, you should call Glad Answers to talk about that, because at least in Massachusetts we have clear case law that says that your subsequent marriage is not valid. So you want to straighten that out. I know it can be difficult if you've moved somewhere where you cannot get a divorce. And they're holding benefits claims by a claimant based on a civil union or registered domestic partnership. I think it's important to note here, this does not extend to claims for children of those relationships. Those claims are being processed because they're not DOMA related. So that's the status on that. So what does it mean that Social Security is holding the claims? What it means is they don't know right now whether they're going to grant or deny those claims, and they're working with the Department of Justice to make that determination. They have been, we of course are encouraging them to work faster, but they're being forthright at least to tell us they don't know right now what they're going to do. But they have said that if they do decide you do not qualify for benefits, then you won't be penalized or fined, and you can also appeal that denial, which we would recommend. I want to make that really clear. We would recommend that you can appeal that denial, because it's possible the Supreme Court will take a marriage case in the next year or 2 or 3, and if you have an open application pending, any benefits you did subsequently receive would date back and be related to the date of your application. And so we can talk to you about how to appeal if that happens. But right now, we're still optimistic that some of these categories of people will be receiving benefits. So we encourage people to preserve your rights and that you should act now, because as I just said, Social Security benefits are keyed to your date of application. Notice I'm not saying that they start from the date of your application. There can be a window when they go back before the date of application, but that date of application is your anchor point, and you want to stake your anchor. I might be mixing my metaphors. Stake your flag, stake your claim. If you are married in or you're in a civil union or domestic partnership and you're ready for Social Security, because some of you won't be right now, you should apply now, even if you live in a state that prohibits same-sex couples from marrying. And that's not just GLAAD saying that, or other legal organizations. That's actually the Social Security's acting commissioner, and it's on the Social Security website that they encourage you, if you think you might be eligible or should be eligible for benefits, to apply now to protect against the loss of potential benefits. Just a note that when you interact with the Social Security Administration staff, they should be pleasant and courteous, they should be respectful, they should not ask gratuitous questions about your relationship, just what's necessary to complete the transaction. And they should be now using gender-neutral terms to refer to relationships such as spouse instead of husband or wife, and parent instead of mother or father. If you have any questions about that or issues, you should definitely let us know. So let me give you some examples then of how this is working out, and I'll start with the 2 end points and then we'll work on the middle. So here we have a married couple that live in a marriage equality state, Liz, the claimant, and Allison, the number holder. They've married in the right time and they're domiciled in Massachusetts or any other marriage equality state. This is the easiest case. Liz files for spouse's benefits on Allison's record. They meet all the other factors of entitlement. This claim will be approved. Now we'll go to the other end of the spectrum. We have a married couple living in a non-marriage state. Sean and Sam are domiciled in Tennessee. They came up to New England, had a lovely fall wedding in New Hampshire, and then went home, and Sean applies for claims on Sam's record. They meet all other factors of entitlement, but remember that the couple, and in particular the number holder, lives in a non-recognition state. That claim will be held, okay? Now we have lots of other scenarios that are in the middle. So you have a married couple living in a non-recognition state, but while the claim is pending, they move to a marriage equality state, and then the claimant files for benefits. That couple will, or that claimant will have that claim approved, because while the claim was pending, they moved to a marriage equality state. Now here we have Richard and Melvin. They live in a marriage equality state and they move to a different marriage equality state, and while they do that, they apply for benefits. As long as that state's not New Jersey, and I think New Jersey will get there eventually, then that claim will be approved. So now we have a couple living in a marriage equality state, Susan and Gail. They're domiciled in Rhode Island, which no question that's a marriage equality state. They married at the right time. While the application was pending, they moved and were domiciled in Texas. Okay, so but they got that application in while they were still in a marriage equality state. They meet all the other factors of entitlement. That claim will be approved. Now we have Brad and George. They're living in a marriage equality state. They married in the right time, and they've moved to and become domiciled in Tennessee. And then they apply for benefits, or Brad files for the spousal benefits, and they meet all other factors of entitlement. That claim will be held because they together and the number holder have moved to a non-marriage equality state before applying. Now we have a number we have the married couple living in a marriage equality state, and just the number holder moves to a non-recognition state. I've been scratching my brain thinking about why one member of a couple would move and not the other. What the best one I can come up with is that somebody retires, but that wouldn't apply here, and they're moving to the new location to get the new residence set up, and they'll be joined later. But here the number holder moves. Perhaps they move for a job and they've decided that the other spouse won't move. So they've domiciled in Massachusetts, married in Massachusetts in the right time, and then Georgia moves and becomes domiciled in Texas, and then Susan files for the spouse benefits, but they meet all other factors. That is going to be held because of the number holder being domiciled in a non-recognition state. Now remember, if the number holder did move on a temporary basis, say for work, and did not change their domicile, then they would still be domiciled in the marriage equality state. So do think about that when you're moving or taking up temporary residence somewhere else. Here, though, let's say that we have the marriage equality couple, and Susan does decide they're going to retire in the South, and that Susan's going to go ahead, set up the domicile in Texas, and then apply for the benefits and get them started in their community. They meet all other factors of entitlement. That claim, I wanted to end on a positive note, will be approved. So I hope those examples make sense to you. It's really about what happens at the time of your application or while your application is pending. And I want to now switch to an example where one of the members of the couple has passed away. So here we have a married couple. They've moved to a non-recognition state, and then the number holder dies, and we have the survivor, in this case Eric, has filed a claim based on Bob's earnings record. That claim will be held. But the difference here between the examples I've given before and this example is that Bob has passed away, living in Florida, a non-marriage jurisdiction. So his domicile can no longer be changed. That is set when he has passed away. Whereas in those other situations, depending on the couple's financial needs and whatever other situation is, they can change their situation. And then last but not least, I think we have a survivor of a same-sex spouse. So Jim and Derek were married in Massachusetts at a time that it was legal. They moved down to DC, and Jim passed away, actually. Derek then later remarries, and he remarries Ray in Washington, D.C. And when Derek is the right age, he applies, you have to be over 60, he applies for widower's benefits on Jim's record. Right now, the Social Security guidance is that this claim will be held, and I just want to be clear that seems wrong, but what they're saying is they're checking into the validity of subsequent same-sex marriage. It should be as valid as anybody else's subsequent marriage, but right now that is the guidance that they are giving. So now I want to drill down into the specific requirements of the spousal retirement benefit, and we will give some examples about how you and your spouse might make this work for your financial future. So anyone who wants the spousal retirement benefit has to have paid into Social Security long enough to qualify, which is, most people have, but you've got to check on that. And we've talked a lot about domicile. As I said, if you live in a marriage equality state, you're definitely moving forward, and guidance is still evolving. You have to have been married at least 12 months prior to applying for benefits. So, and Social Security has an interesting way in counting months. So they do round up. So if you got married, say on November 18th, then the subsequent November 1st, you will have hit the 12 months, even though that's not actual 12 months. And you have an age requirement here, which is you are at least 62 years of age, or any age if you have a qualifying child in your care who's under 16 or disabled. I'm not going to go into detail about what a qualifying child is, because I could talk for an entire hour on that subject alone. Social Security, it's actually not enough to be a biological child in some circumstances. They have other requirements trying to interpret the word child broadly because it's a social safety net program. Call Glad Answers if you have questions about that. And I should say, too, that you can only get a spousal retirement benefit if your spouse has filed for retirement with Social Security. They can file and suspend and not collect it, and that's how you deal with that. But your spouse has to be old enough. So I know one question that came in before we even started today was a situation where someone is of Social Security age and collecting, but their spouse is still working, is 58 and is the higher wage earner. So they're going to have to wait to get a spousal retirement benefit until the spouse retires. So that's how they will handle that. There is a limitation, as I explained before, which is you are not entitled to a benefit on your own record that's greater than half of your spouse's benefit, unless you want to use the spousal benefit to earn delayed retirement credits on your own record. And I'll get into the details of that. There is no deadline for applying, but as I've emphasized, you can only go back from the date of application a certain amount of time. So you want to make sure when you're ready that you get your application in. So no deadline. This is as good a place as any to mention that lump sum death benefit, which we're not going to go into detail about. There is a 2-year deadline from the date of the person's death. Now, there are a lot of factors that affect the amount of your benefit. Age is probably one of the biggest factors, and this is a chart I've taken right from the Social Security website. It's just an example, but for people who are retiring now, or if you were born before 1960, your full retirement or normal retirement age is 66. For folks who are a little older, it might have been a little bit younger. Social Security is extending the retirement age, but your full benefit in this example, the person's benefit is $1,000, but if they retire early, then they're going to have I don't know if you want to call it a penalty, but they're going to be paid less. That's because theoretically they're going to be paid for a longer amount of time. And if they delay their retirement up to age 70, then they will receive substantially higher payments. And remember, when you get your payment base, like that $1,000, or if you delay the 1320, every cost of living adjustment is a percentage, so that really factors into higher benefits as you go along. So it's not just at the time that you're retiring. There are other factors that limit benefits amounts. The windfall elimination provision applies to people who have significant government pensions, and it can in many cases limit your Social Security benefits. The government pension offset is something that applies to spouses who are trying to get benefits based on their spouse's earnings record. And there is a maximum family benefit that does not apply at all to the worker's benefit, but if you have a spouse and children claiming on the wage earner's record, then they collectively will hit a certain benefit cap. And so you need to just think about that as you're making your applications. The survivor benefit has fairly similar requirements. Your spouse has to have paid in long enough, and we've already covered domicile. It has a slightly shorter marriage duration requirement, 9 months, so anyone who's had a baby can guess why 9 months is the limit here. And you have to be at least 60 years of age or 50 and disabled, or of any age if you have a qualifying child in your care who's under 16 or disabled. Now, this is different from the spousal benefit. You have to have not remarried before age 60 or 50 if you're disabled, unless the later marriage has ended, which by the typical means death, divorce, or annulment. So if you have remarried before age 60, then you cannot collect on the first marriage, on a survivor benefit on the first marriage, until that second marriage ends. Now, I know we had a caller early on after DOMA was struck down who had a long-term relationship with a husband, and then he died, and eventually she remarried somebody else before she was age 60, but she was already collecting benefits at the time that Windsor was struck down. So I think she's okay because her application was processed in accordance with the rules in existence at the time. If you did enter into a marriage before age 60 and you have not started collecting benefits, it's possible that Social Security will say you cannot until that second marriage ends. I would encourage you to call GLAD Answers. We haven't received that call yet. I don't know if we can help you, but we can try. Benefits limitation here is the same situation. Your monthly benefit amount should be lower than the benefit your deceased spouse was receiving, and then you'd switch over to the higher benefit, unless you want to use the survivor benefit to earn delayed retirement credits on your own record. And again, no deadline for applying, but you can't go back and get missed months. So maximizing your benefits is an important part of Social Security's strategy, and it's very important to learn these things. I have now doing all this work to get this presentation and earlier publications together. I've talked to a whole lot of same-sex couples and LGBT people who are over the age of 60, and I find that generally we don't know, the community does not know a lot about Social Security spousal benefits, and that kind of makes sense to me. Why would you want to learn about something that discrimination prevents you from getting? It sort of adds insult to injury. So it's important you learn this and do your research here. So for example, specifically, if you wait until your full retirement age to apply for benefits, you can use either your own benefit or your spousal benefit to get a higher benefit. If you apply earlier, if you apply before your full retirement age, you can't do this. You have to accept the largest benefit to which you're entitled. It's just one of Social Security's rules. Again, I want to put some names and numbers to this. So we've got a married couple. Let's assume they've married in a marriage equality state and they live in a marriage equality state. So and they're both full retirement age is 66. So Betty was the higher wage earner, and her benefit if she retires at 66 is $1,900. Veronica has a choice. She can retire on her own benefit, and she's earned a benefit of $1,000. Of course, her spousal benefit would be $950. So at first glance, you're thinking, well, she wouldn't want to go for the spousal benefit. But if she waits to collect on her own record, her benefit would be $1,320. So now they've got to really think about their situation. How long do they think that each one of them is going to live? Of course, we don't have a crystal ball, so you're making your best estimate. Do they need the money now and they can't wait for the money? They've got to factor these things in. So at age 66, Veronica has a couple of choices here. She could draw on her own record and take the $1,000 benefit, or she could take a little bit less here and draw on her spousal benefit only, and then at age 70 she would switch over to her own retirement benefit, and she would literally collect $320 a month plus cost of living every month more for the rest of her life. So that's one of the ways that you can use the spousal benefit or the survivor benefit to help you maximize your benefits. And I've got that age chart there just to show you again, to emphasize that how that, your age at the time you claim benefits can make a difference. So now I'm going to take a different couple, David and Rob. They're both a little bit younger, 62. David's full retirement benefit amount is $2,000, and he has a life expectancy of 80. As I said, you're looking in a crystal ball here. You just don't know. So some people, you could get hit by a bus, or you could live another 25 years. But you make your best calculation. Rob here was the lower earner. His retirement benefit is $700, but his life expectancy is longer. He's expected to live to be 90. Now, they can both claim at 62, and the fact is about 80% of Americans do claim at the earliest possible opportunity. They will get reduced benefits for the rest of their life. And I say reduced in the sense that the monthly amount is reduced, but of course they're getting benefits for a longer period of time. So at some point, if they live long enough, they will have been better off waiting. But right now, this is what they've chose to do. So David will get $1,500 a month, and Rob will get $525. David does as predicted, and he lives till age 80. And at that point, Rob will step up to the monthly survivor benefit. He'll switch over from his $525 a month to $1,500 a month, and he'll collect that for 10 years until he dies at age 90. And their total lifetime benefits are $635,000 or so. Now, and again, that age makes a huge difference here. So let's vary this scenario, though. What if David waits? They decide David will wait until 70 to claim benefits, but Rob will claim his benefits early at 62. And so that means he'll get $525 a month. And of course, you have to be able to afford to do this. So when David eventually claims, because he's got these delayed retirement credits, he's going to get a higher benefit. He's going to get $2640 a month until he dies. And at that point, Rob will step up to the survivor benefit for the last 10 years of his life. And look at the difference here. It's over $112,000. Total lifetime benefits for them are $747,000. And I promise this is not a commercial where I say, well, wait, there's more. This is our last variation for this couple. What if David files for and suspends his own benefit at 66? So he's not collecting. He's still getting delayed retirement credits, but Rob waits until 66 rather than 62 to take that spousal benefit. So if he does that, Rob will get $1,000 a month rather than $525 at age 62. And at 70, David will then reapply for his delayed benefit, which is now worth that higher amount of $2640 until he dies. Rob switches over to the survivor benefit. And the total lifetime benefits are $961,000. So you can see huge difference here in the amount of benefits this couple takes if they can afford to wait and if they strategize to maximize their benefits. Now, I know from the questionnaire or the information you provided when you signed up for the website that a large number of you are already collecting Social Security, and you were before the Windsor decision issued. If DOMA had not existed and had not discriminated against the community, then Social Security would have helped you maximize your benefits. But it did, and you started collecting, and so now what? Can you do anything? And we think the answer is yes. Social Security has not provided us with guidance on this, so we want people to be asking Social Security about this, and we're asking Social Security about this, but it helps to have real people out there. And we do think there are some strategies that you can employ, and the reason, as I said before, is about 80% of people take benefits at 62 and then decide that might have been a mistake and they want to try to fix it. And so the strategies those people employ might work for you and your spouse. So the first option is for you to actually withdraw your original application, and this only applies if you are within the first 12 months of starting benefits, okay? We just talked to a couple, I think it was last week, that was at 11 and a half months, and they realized this, and they went back and they had the one spouse withdraw the application. And it's easy to do. The only issue is you do have to pay back all of the money you have received already. So Social Security is supposed to approve your request, and if they didn't, we would want to hear that. And if they do, then they treat you as if you had never started benefits. It's kind of called a do-over, and you only get one do-over in your life. So we want that you say this do-over should not be counted against you because it was the result of a major change in the law. There are two other options. Option two, don't shoot the messenger, is to go back to work. If you're outside the window of the 12 months, or you don't have the money to pay it all back, but you are under your full retirement age, which for people now is 66, then if you earn enough money, they will just automatically reduce your Social Security benefits if you go over a certain threshold amount, which I'm going to cover in a minute. And you don't lose these benefits. They're just sort of added on as if you had delayed retirement. So you're kind of, it's like a backdoor way to get where you wanted to go. These are the earnings thresholds. If you are under full retirement age and not in the year when you're going to reach full retirement age, the exemption amount is pretty low. I don't understand why, but in the year that you reach full retirement age, the exemption amount is much higher, although it applies only to the months prior to the month when you turn 66. But those are the numbers, and Social Security should be able to talk you through all this. Your last option is to do what's called voluntarily suspend. So if you're outside the 12-month window since starting benefits and you are of full retirement age, you can voluntarily suspend your Social Security income, and then you get credits for delaying. Now, the most you can do, then you're going to restart benefits by age 70. But again, for every month you are suspended, you will be increasing your monthly benefit for the rest of your life when you do start drawing. So at the same time, I would be raising this issue with Social Security about whether or not you could be claiming on a spouse's benefit or a survivor benefit. So the last thing I promised to cover was civil unions and registered domestic partnerships, and in a minute, children. Social Security defines wife and husband very broadly. Part of this had to do with the fact that people, many, many decades ago did travel and didn't necessarily obtain a divorce before they married somebody else. And Social Security is a safety net program, so they were trying to capture people who might otherwise not receive benefits. So they have a very broad definition, and it turns out that one of the definitions of spouse includes a person who would have the same status to inherit property as a spouse if the wage earner died without a will, so if the wage earner died intestate. We believe that this covers civil unions and registered domestic partnerships, and in fact, there's very good argument for that. And so if you're in one of those relationships, you want to rely on Social Security, you should apply for benefits when the timing is right for you and your family. And we're not the only ones, again, who are saying this. Social Security specifically says they're working on this issue of civil unions and registered domestic partnerships, and they're encouraging you to apply right away if you're ready for benefits to preserve your filing date. This same argument has actually already helped children of same-sex couples. So children of married same-sex couples receive benefits like any other child, but children of civil unions or other relationships also might be eligible to receive benefits, and that's because, as I mentioned, this very complicated definition of child under Social Security includes people who would, if there was no surviving spouse, be able to inherit if the wage earner died without a will. And so those children are often protected, which is good through the Social Security safety net. And I think that is the end of our presentation. That you guys were awesome with the questions. I know this is complicated material, so I'm glad it's recorded. You can listen to it again. And as I say, please, we really welcome the calls to GLAD Answers. The volunteers there have a lot of information, and if they can't answer your question, they will get an attorney to help. And we want to basically end the discrimination that DOMA has brought to the community, and that includes all these details. Thank you.